Okay, welcome to Nuts and Bolts and New Ventures. Tonight, this session is going to be about legal issues. I'm Joe Hadzima, as you see on the screen. First thing to say is this is for background education only. It's not legal advice. And the reason for that, there are a couple reasons. One, laws and the interpretation of laws change over time. So what I say tonight could be wrong tomorrow. And secondly, the application of those laws to specific facts is where the issues are. So don't assume what you're learning tonight you can apply automatically. If you think back to the first session when we said only 10% of entrepreneurs succeed, or businesses succeed, and our goal was to try to improve your probability of success, you can think of tonight as trying to improve your probability by showing you things you ought to be aware of, so that you'll recognize when they come up, you will either be ahead of them or you'll know that you've got an issue. One of the things that all the people that have been speaking to you can say that they have experience in is making mistakes. And so when you make enough mistakes, then you get wisdom, I guess. So that's how we start. And with that, let's get going. I'm going to go through tonight in sort of with two dimensions. One is the life cycle of your venture from initial idea to way down the road. And I'm going to look at several different components and try to tell you things from each of those that may be relevant at what time. So we'll start off with the idea stage. And when you have an idea for a company, if it's technology or anything that's sort of proprietary, the question is going to be, well, who owns it? And then secondly, how do you protect it? And so the way to handle both those together is I'm going to talk about different types of intellectual property, because the ownership of that property differs depending on which one you're talking about. So at the end, hopefully you'll get a sense of that. Now, why do we care about intellectual property? Well, in 1975, 17% of the market capitalization of the S&P 500 companies was represented by intangibles. What are those? So you take the stock market price times the number of shares, that's the market cap. You go to the balance sheet and you say, what are the tangible assets? Buildings, equipment. And you subtract that from the market cap, and what's left is intangibles. And these include things like, brand, human capital, intellectual capital, and then eventually intellectual property, which is how do you take intellectual capital and turn it into something that has protection and value. If you look at that over time, in a short period of time, 84% in 2015 of the S&P 500 market cap was represented by intangibles, things that weren't hard assets on the balance sheet. So it's sort of really important in the big scheme, and certainly for startups. So let's talk about the types of IP protection. In one case, we have none. You don't do anything, either because you choose not to, or there's nothing you can protect. And then we have a trade secret. Now, we're going to get into what these things are in more detail, but at a high level, a trade secret is something that you can use to prevent others, in the sense that if you know the secret and they don't, they can't do anything. The next two, copyright and trademark, these can enhance value. When you think of Nike as a brand, a trademark, or you think of a copyright in a book or something, those enhance value, but they don't prevent others from doing something similar. Coca-Cola is a brand, Pepsi is a brand. I know people say, one tastes different than the other, but they're both sort of the same thing, despite all the money that you're going to spend on advertising. Patents cut both ways. If you get a patent, as you'll see when we talk more about it in a few minutes, you can prevent others from practicing your invention that you patented. But in order to get that patent, you have to disclose your invention. So you're sort of enabling people to look at it and build on it. So it cuts both ways, and we'll see some examples of that. And you can have combinations of protections. Software can be protected by patent and copyright. So if we look at the big picture and we look at duration, patents have the shortest duration. In the US, 20 years from the date of filing. Trade secrets could last like forever, right? If it's still secret. And of course, cost is sort of goes the other way, right? So the thing that has the shortest life is probably the most expensive. That's not to say that people don't spend money, I'm talking about protecting, the legal protection of the property. If you're Pepsi or Coke, you're spending a lot of money, super bold ads to get people to recognize your brand, but the cost of getting and protecting the asset. Now, these intellectual property categories apply on a country-by-country basis. So if you get a patent in the US, you don't have one in England or the UK, there's different things going on there. I'm going to focus on the US tonight. And when you go internationally, it's a bigger set of issues. Are we good so far? Okay. The other thing I'm going to say, I should have said at the beginning, Bob Jones talked about having a presentation where you spoke slowly and you emphasize points and you have 3 things that people want to know. My goal here, again, to get you to realize their issue is I crammed a lot of stuff in here. So I'm going to move through some of these quickly. This deck is on the website, nutsandbolts.mit.edu, session 5. And as you'll see in the presentation, there are links to other things with more detail. So let's go. Trade secret gives you an advantage if nobody else knows how to do it. I'm going to do a little reading here. Coca-Cola is the famous example. Supposedly it's a secret formula. No one's been able to reproduce it. It lasts as long as you keep it secret. So one of the things is to keep it secret is using non-disclosure agreements. Both with your employees, consultants, and even partners. And those vary state by state, depending on the state in which you're involved. For your venture plan or pitch, if you have something that's really a trade secret, you don't have to put it in there. You shouldn't put it in there. You're trying to, as Bob would say the other night, you're selling the benefits. What is it that's so valuable that you're doing? You don't have to exactly explain how you're doing it. If they do invest, they may get down into details, but most venture capitalists will not sign non-disclosure agreements, and the reason is, they say, it can constrain them. You may come in with an idea, 3D printing. Wow, it's here now. So you come in and I sign non-disclosure, and then you come in, and I think, well, that's good, but I think he can execute better, and now I get sued potentially because I took your idea and gave it to him. So they'll just say, no, we don't want to know anything. It's at your risk. Trademark and service mark. A trademark relates to goods, and a service mark relates to services. And think of it, it can be a word, a phrase, a logo, a color even, or a sound, that when a consumer hears, they associate it with a particular source of goods or services. And that's how it's measured. So you can have, famous case was between, Lexus, the online search thing, and Lexus, the automobile, right? And so Lexus and Lexus, and the question was, were those infringing each other? Well, the people that saw Lexus didn't think they were buying, a car. They were thinking they were buying a service, but that's the distinction. Examples of marks can be multi-layer. One is at the entity level, a house mark, and that would be like Lenovo or Virtual Ink, our case study, or MGM, where the lions roar at the beginning of movies. Says that's the house, so to speak. Now, the product or service underneath would be, in the case of Lenovo, it might be ThinkPad, the computer we're using here tonight. Mimeo, which was that video we saw in the first night, or Rocky the movie, can separately have a trademark. The rights arise from use in commerce. Historically, that is, you had to go out and actually use the mark by delivering a service or selling goods. Now, the problem with that is if you're mounting a big campaign to bring a product to market and doing all the publicity and all of the literature and everything, and don't know whether you can protect that mark, that's sort of an expensive thing. So there is a provision called intent to use. And there you file with the federal government and say, I intend to use this mark for these goods or services. And you get a couple of years of leeway, knowing that you can actually have a mark that you can use. And then when you finally do put it into service, so to speak, then it becomes a real mark. When you use a mark, it arises at common law. And to show it, you put a TM, a little TM, above the word or phrase or symbol, or SM. And you can register it federally in the US at the US Patent and Trademark Office. And when you get that registration, you can use a little R and a circle, registered. And what that means is you have rights over anybody else in the country to use that mark for those goods or services, except for senior unregistered users. A classic example of that is when McDonald's, our Golden Arch people, got the trademark for McDonald's. There was a restaurant in upstate New York called McDonald's that had been there well before McDonald's, the Golden Arch. So they could continue to operate in their geographic area. But other than that, no one else could, after that thing was registered, could come and say, you know, I'm going to set up a McDonald's restaurant. It's best to use a fanciful mark, Apple for computers, or something like that, as opposed to a descriptive mark like storage technology or analog devices, which merely describe what it is. In fact, if it's merely descriptive, you probably won't be able to get a mark at all on it. And to see if it's available, go to the USPTO, US Patent and Trademark Office, and you can actually search. And you'll say, I want to use this mark for, you know, toothpaste. And they have different categories, and you can see if it's available federally. Okay, moving on. Copyright is, yes, the right to make copies. And it arises from creating a work. And in fact, if I write a letter to my mother, there's a copyright I have in that. Now, in order to protect that, I might have to do some other things. It protects the expression, not the function. So if Shakespeare could have had a copyright on Romeo and Juliet, you know, West Side Story could not have been written, right? Because that's similar, that's basically an updated version of Romeo and Juliet. So, but if I tried to use the same words or the same sequence, that could be copying. Federal registration is a must or helpful because you can sue for infringement, but you have to register. Duration is long, 70 plus years. The cost to register is low, less than $100. And it's useful to put a notice, as you see on the slides here. I have copyright year, whoever's copying that, and all rights reserved. You can use the C in the circle once you've registered the mark federally, but put it that way. Now, the question of, we said at the beginning, who owns stuff? This is where people often trip up with startups. So the person who owns a copyright is the author, the person that actually wrote whatever it is. And software can be copyrighted. So the only place where the person who writes it is not the owner is if it's an employee writing the software for an employer, in which case the employer owns. Or if you're an independent contractor and you've agreed to create a work for hire, usually under an agreement saying that the person who commissioned you owns it. So where people trip up is they say, oh, you know, we'll get somebody to write some code. I had an example of this back when I was practicing. A company had spent $500,000 for an import-export software program, custom made for them. And then about 3 or 4 months later, they found out a competitor was using the same system. And they came to me and they said, we can't do that, we paid for it. And it turned out, well, they didn't have an agreement saying they were going to own it. And in fact, the vendor could take it to someone else. So we had to work out some way to make that, work. But the fact is, since they didn't have something in writing that said this is a work for hire, there was a problem. Now, some of you may actually go out and be programmers yourself, and especially if you work for a large company, they're going to say, here's a consulting agreement, and anything you write is owned by the company, the big company. And so you have to say, well, wait a second. I program using modules I've written. I'll assemble them in certain ways. That'll be something you can own the whole work, but you can't own the individual pieces because I'm going to go and assemble them for somebody else. And so when I encounter that with a company, I usually have a whole page I've written up explaining what our model is and why it doesn't make sense and why we can't do it. Because the first reaction is, we've got to own it for this very reason. So the two sides of this, if you're a startup commissioning work, make sure you have the rights to it. If your business is in software or other creative things, and make sure that you don't sign away those rights inadvertently. So far, so good. Also, open source is an issue. Under open source general licenses, you can use modules. If you change the code, you're supposed to contribute it back. So if you write your stuff where you take modules of, like a MySQL, and your application code calls on it but doesn't change the MySQL code, that's okay. But you want to check it because if it comes time for to acquire your company, somebody will check and see if your code, is compliant. Otherwise, it's a problem. Okay, patents. Patents are a limited time monopoly. We don't like monopolies in the US. We have antitrust laws. So why in the world would we give somebody a monopoly? Well, in fact, this goes back to the Constitution. The theory is if somebody were to disclose their invention, how do they prevent others from taking it away, copying it? And so the societal bargain is you disclose your invention, and if we agree that it meets the requirements I'm going to tell you about, you get a limited time monopoly to control who can use that invention. And that's viewed as a good trade-off because the information gets out there, increases the knowledge base, people can build on it, and that's how we advance. So that's the theory. It has to be applied for, unlike trademarks or copyrights, which can exist without being applied for. They just exist when they come into existence. Advantages are if you register them. In the case of patents, you have to actually apply. It's granted country by country. And essentially, it's very much like real estate. The fundamental right you have when you own a piece of property is to prevent other people from trespassing, from walking on your property. It doesn't mean you can actually use your property. That strikes some people as what? I can't use my own invention. Well, just like if you had a landlocked piece of property, I could prevent you from coming on my landlocked, but if I had to walk across your land to get to mine, I wouldn't actually be able to use mine. I'll give you an example of that in a moment, but let that sink in for a moment. It's to prevent us from making, using, selling, distributing, or importing the patented invention. So if you have a patent in the US and somebody takes that invention and goes to China and makes that invention, that thing, and brings it into the US, you can prevent them from bringing it into the US because it would violate your patent in the US. They can make it in China and sell it in China or other places where you don't have a patent. Again, just talked about not the right to use. The claims of the patent define the real estate. What exactly is the invention? And that's where, when you're dealing with patent lawyers, that's where they earn their keep, if they can write really good claims to make a strong property for you. Duration in the US for utility patents is 20 years from the date of filing. Okay, so here's an example. You patent a vessel to hold a liquid. I patent a handle. There can be no handle on the cup or cup on the handle unless we both agree, and that would be a cross license. That explains, hopefully explains the idea that you don't actually have a right to use your invention necessarily. I can't use my handle except by itself. If I want to put it on something else, I potentially could infringe the cup patent. Okay? How do you get it? What do you need? First of all, it has to be something novel, new, nobody's ever done before. And you check prior art in order to figure out whether it's new. Prior art means things that have come before. It could be prior patents, could be other things people have written about. Those have to be, that's part of the examination process when you file a patent application. It has to be useful. That usually isn't a problem, but I suppose in some cases it is. It has to be patentable subject matter. Process, machine, manufacture, or composition of matter, or any new and useful improvement thereof. So the courts get themselves all tangled up in this. The big thing going on right now are things like business method patents or software by itself. In other words, if you take something that people are doing manually and you simply write code for it, they say, well, that's not really, patentable. So there's a lot going on, and the lawyers spend a lot of time writing about it, and eventually it'll all sort out. That's why you go to the patent lawyers to help you figure it out. It cannot have been previously offered, sold, or publicly disclosed. So by disclosed, I mean it's an enabling disclosure. So if I sit here and I stand here and say, I've invented anti-gravity boots. You can all applaud me, but I haven't told you how I did it, so it's not an enabling disclosure. If enabling means someone could actually take it and try to make it. In the US only, there's a 1-year window from the time you publicly disclose, or offer for sale, 1 year in order to get a patent application on file. And if you do that within the 1 year, you're okay in the US. In the rest of the world, you're probably dead. So I was in Istanbul talking to a team from Egypt. They had a new technology for high bandwidth wireless communication. And I said, have you got a patent on this or an application? They said, no, we're thinking about it. I said, have you published any papers? Oh, yes, we've got this great paper. And so I said, oops. I said, I don't, and when did that come out? And I said, if you hurry, you might be able to get it in the US. I'm not sure any place else in the world. And you could almost see them, sag in the chair because they didn't understand that. So the trick is to file first before you disclose. And I'll show you some easy ways to file. Holding out for sale is a tricky thing. If you try to license something, that could be holding it out for sale. A classic one was somebody had a improved women's bra that, they went to a show, they never actually showed the bra, somebody wore it, and the court said, well, that was actually offering for sale or, publicly disclosing. So, check with your lawyer before you do that stuff. The invention can't be obvious to one of ordinary skill in the art. And so this gets into a little issue sometimes at MIT. There's a venture mentoring service. There was a professor who we were mentoring, and he had this new chip thingy, and he said, I did a little paper about the concept, but I never really disclosed what it was exactly, and anybody could figure it out once I did the paper. And I said, oh, I'm not too sure about that. You really ought to go talk to a patent lawyer, because what you think is obvious to one of ordinary skill in the art as an MIT professor may not meet that requirement. And in fact, it turned out it wasn't. He got the patent, started a company, they sold it for $300 or $400 million a couple of years later. But he would have not done anything on that one. And how could you show it's not obvious? In one case, you say, well, everybody else out there said it couldn't be done, and I've done it. Bob Langer tells a very good story about one of his first patents when he came to the patent office and said, well, here are all these things saying it can't be done. I did it, so it wasn't obvious. And he was able to get the patent. And the other thing is commercial success could be a way of showing that. You know, I put this product in the market and everybody wanted it. Why did everyone want it if it was so obvious that nobody else had done it? And we used to be in the US, the rule was the first inventor to file wins. The first to invent wins. And so people would keep lab notebooks and date stamped and all that stuff. We switched to a new system, which is the first inventor to file. So if two people both invented, the first one to get to the patent office now wins, assuming the patent issues. So that becomes really interesting when you're doing joint ventures with other companies and you don't have an agreement very clearly stating who owns what. I'll do a quick question, but.
So about the duration, if the patent expires, can you refile for it, or is it just start?
No, it's once the 20-year, the question is when the duration of the patent expires, it expires, and you can't infringe it after that. So what people do is they'll file, you build a patent family. You know, you have a cup. I invented a cup. And now I want to extend that patent family, and I invent the handle as a continuation of my invention. And so you do this and you extend the patent life. We're doing that now with a company. We licensed this big company, and we're building out a patent family which is going to extend the life of the royalties. So that's how you get around or deal with that. Let's see. So what you want to make sure when you're starting a venture is, are you free to actually do what you think? Is somebody else done it? Is somebody else got a patent? Do you need to license something from someone? We'll touch a little bit on licensing from MIT. And what is your strategy? I'll talk about patenting versus disclosing to others. So you really need to think strategically about it before you launch. And investors are going to want to know, you know, do you have a patent? Often they'll require a freedom to operate opinion from a law firm. Further talking about this, basically inventors don't want to buy a lawsuit. You'll see when Yano comes in tomorrow, he'll talk about his IP story. I think he has a little example of that. Okay, so how do you find out whether the prior art is out there? Well, you can search. There are all sorts of search databases. This is a company that I co-founded, IP Vision. We were doing a lot of early stage commercialization of technology from MIT, very early stage stuff, and we wanted to make sure, you know, we do these patent searches. In one case, we got an outside opinion, and when we got actually out in the field, we realized it was perfectly accurate as far as it went, but we couldn't really figure out what was going on in the space from what the lawyers were telling us. So we invented a way to visualize it. These are patent maps, seetheforest.com. If you're an MIT student or in the class and you want to use this, you can sign up for free and then send me an email and put nuts and bolts and the titles and see the forest, and we'll upgrade you. Use the email address you registered on, we'll upgrade you to the premium version. Examples of what's here. This is Virtual Inc.'s first patent, the Mimeo. So how you read these maps is time, horizontal. Each of the boxes is a patent property. The left edge of the box is the issue date. The tail shows you the filing date. And the lines connecting the boxes are the citation references. Now, what is that? When you apply for a patent application, you have to cite all prior art of which you're aware to the examiner. And then your lawyer normally knows that, and the examiner knows stuff. And unlike the citations you might have in an academic paper, which might be political, you know, I want to cite my professor's book. The issue here is if you fail to cite prior art of which you're aware, it can be the basis for invalidating an otherwise perfectly good patent because it's viewed as fraud in the patent office. So these lines have meaning to help you understand what's going on in the space. So that was their first patent when they issued. these were the companies that are on that map. So either they can think of this as, are these competitors? Are these people trying to solve a similar problem that might be partners? Might be people who'd be interested in acquiring at some point. This is what the map looked like a few years later, where Yonald's patent was in the middle and these other companies are citing it as prior art. He went to build out a portfolio of on the left you'll see a bunch of patents sort of right back on the third or fourth line over, and the forward citations, the patents citing them. This was back when he got going. In 2012 and 2019, the number of people citing him went up to this. It became really a, sort of a mess of people citing him. By using these visualization techniques, you can start to ask questions. Are we building the right thing? Who do we want to partner with? Do we want to do something in this area? A lot of early stage technologies can have 5 or 6 different areas to go. And all things being equal, you might want to do it in an area where you can build something out and get protection. Anyway, you're free to play with that. The application or the process he's thinking about what do I patent? When do I file? Preparing the applications, et cetera. So the natural tendency for inventors is to say, well, I invented it, we should file. And the real question is, not what can you file or get a patent on, but what adds value to the company as part of the strategy that you're doing. How would your competitors use it, and how does this compare against prior art? You want to file before you lose U.S. or foreign rights. That's that 1-year window in the U.S. If you file in the U.S., by the way, it's treated as filing for the rest of the world. So file here first, or file someplace else first. But if you wait until after you've disclosed, it's only in the U.S. you'll get it. In time to have a patent to protect your product or service. So timing is everything. We're in the middle of this negotiation with a big consumer products company, and we had like 6 or 7 applications filed, and they were doing, what if it doesn't issue? And we had all these drafts, and I came in one Monday, and I got an email from the patent lawyer saying, our patent is issued in, patent number 1 is issued in the US, Europe, and China. And so I walked into the negotiation saying, we just got 3 of the patents issued. That changed the whole discussion. All that stuff came out about what if it doesn't issued, and all of a sudden it broke a log jam in negotiations. So the timing would happen to be fortunate there. So I hope you could, well, it's better to be lucky than smart. Well, if you're smart and lucky, you're in good shape. As you'll see in a moment, patents are expensive. And, you're a startup, you don't have a lot of money. So there's this thing called provisional patent applications. And this was, in part, a reaction to this idea that the rest of the world only accepted application, or said if you didn't file, you'd lose rights. So a provisional application is simply something that describes your invention. It doesn't have any claims. It just says, I've invented this and stuff. And it establishes the filing priority date. You did it on this date. You have a 1-year window in order to convert that to a regular patent. So think of it, you can get a provisional file, and now you can go out and talk to people, knowing that you've established a date for whatever the invention is described. So you have some protection there. It's cheap, $120 or $60. Nothing happens at the patent office, the PTO. In fact, it doesn't even get disclosed. When you go to file the actual application, and you start claiming things, the question will be, did your provisional explain enough that you can actually file a more complete application? So let's say I filed an application, a provisional that said, fruits and vegetables are good for you, and nobody else has ever figured that out. And then in the course of the year, I realize, protein's important too. And so I go to file a full application, and I say I claim fruits, vegetables, and beef. Well, since beef wasn't described in my initial provisional, I won't be able to get that early filing date. I could still get a later filing date as long as nobody else came and figured that out in between. And when we were developing the IP Vision system, we did yeah.
So is just for the claim about the beef would be problematic, or the entire thing?
No, you could claim the stuff that was described in the provisional, and then you'd have to file a new application for the beef. And if Moses came in between the provisional and your utility and happened to file or disclose something about beef, you're out of luck. So, in fact, people have taken papers they're going to give at a conference, slapped a cover page on it, and filed it, and that works. So when we were developing the IP Vision system, it's software as a service. We had 6-week, revisions. Every time before we did a release, we'd sit down and say, well, what do we think? What was important that we did that we think has value? And we'd file an application on provisional on that. What did we think about doing that came up during our thinking about this that we didn't actually implement, but we think has value? We'd file it on that. So we had applications going in every 6 weeks. And so after the first one hits a year, we had to make a decision. All right, do we want to turn that into a full patent? But at least we preserve the rights for short dollars. Okay. How many people have actually read a patent? Anybody have a patent? Oh, a couple. Okay. If people read a patent, if you have insomnia, it's a great thing for most patents. I find them kind of hard to sit down and read. But you typically describe the field of the invention, the background. People are doing this today, and they have these deficiencies, and my invention is this, and it makes it better. And then you summarize the invention. It's important to then go on to describe it, because in order to get the invention, you have to describe the best mode of practicing. Remember, the idea is you just describe your invention, then you get the patent. And so if you have actually a really good way of doing it, but you don't want to disclose it, and you do a second-rate one, and someone said, well, he really didn't describe the real way of doing it, that could be a basis to invalidate. And you give some claims, and the claims are really defines it, and that's where the lawyers earn their dollars. Costs, it can be expensive. I just said $5,000 to $15,000 to file an application. I had a co-founder who, without telling me, was talking to the patent lawyer all the time, and I got a bill for $35,000. And I went to my co-founder, I said, you come to me first before you talk to the patent lawyer, because otherwise this is out of control. Filing fees, you can't really control what the prosecution of the patent is going to be, because you submit the application. The examiner usually rejects it for some reason. In fact, if they accept it right away, then you worry that you didn't claim enough. But you go back and forth. And every time, it's like a tennis match. Every time they hit the ball, you got to pay to hit the ball back. And the question is, how long is that rally? And it's sort of, can be unknown. Patent applications international get more expensive. There was a study from the General Accounting Office that said in the 10 industrialized countries, depending on the nature of the invention, because some charge more than others, to file and maintain a patent in the 10 major industrial patent countries for a small company, which pays fewer fees, was anywhere from $300,000 to $500,000 over the life of the patent. So they're expensive, but can be valuable. Now, a way to, if it's so expensive, is there any other strategy? Well, you don't want to get caught in a picket fence. Now, what is a picket fence? Suppose I invent a vessel to hold a liquid, and you come along and say, gosh, that would be great if there were a cap on it, because it wouldn't spill, I could carry it around. And maybe you come along and you say, oh, maybe a handle would be good, or maybe an insulated sleeve or a styrofoam, and you patent all these things. The net effect is, I really can't take my vessel to market because you patented all of the commercially interesting things in the commercialization of it. All right, so that's sort of a picket fence blocking you in. So the way you avoid that, if you can, is if you think the core invention is so strong and the lawyers think you can get a really strong patent, you could disclose all that stuff. You could disclose the cap, the handle, you could do a lot of things. It doesn't mean that you actually have to claim them or write an application, but once you've disclosed it, I can't come along, or you can't, or somebody else can't come along and file a patent on a handle because it's already been disclosed. So that's sort of the picket fence. You do it carefully, but in some cases it's very effective. A quick one? Yeah?
Yeah, so you basically mean essentially like, let's say you're the like that's valid for a year,
Mhm.
and in that you might also find all these other things.
Yep.
Then not be that's
No, because you've claimed it, you filed an application. Yeah, that's the other way to do it. But after a year, you're going to have to either file a patent application, a full application, or disclose it to prevent somebody else.
you're saying even without filing,
You could, yeah. So, yeah, I know we can go into a lot of detail. I'll take one more, though. Yeah. Oh, disclosing. Okay, so I could disclose, let's say I disclose, typically let's say I file a patent on an office a suite of furniture consisting of a desk, a chair, a lamp, and a bookcase. Now the patent office might say, well, those are separate inventions, so I want you to split them into 5 different, one for each of those. Now I have to file and prosecute 5 patents, and it's going to be expensive. So if I really cared just about the lamp, I might say, the lamp, configured with a desk certain way, and then I could disclose the other things and say, you could use it with behind a chair or in front of the chair or on top of the bookcase. In other words, you disclose it so nobody else could claim that it was their invention. Or if they did claim it, they'd have to show that they invented it before you filed. So it's the way to think of it. Here's an example of a picket fence. Anybody got a Ring doorbell camera? If you do, that's the application for one of the original application in the yellow on the left. And you see all the red colored boxes around it? That's Skybell. Those are patents that Skybell got. And if you look at them, there are a lot of things that could be construed as a picket fence. They actually ended up in some litigation before Ring went public. And you don't want to, that's a good example of it. Now, what can you do with patents other than just enforce them? Well, here's a quote from Tesla in, 2014? They made available a bunch of their patents to the marketplace, freely licensed with certain conditions. Now, why would they ever do that? Yeah.
because I guess in order for their vehicles to work, you need a lot of charging stations. If there are more people in the marketplace, they will be interested in getting.
Sure. So you can enable other people, right? Just like, Henry Ford, when he invented the Model T, in order to get people to buy that, the roads weren't there, the gas stations. In fact, people would buy gasoline at the hardware store and carry gasoline in jugs with them because there were no gas stations. There weren't refineries. So in order for him to be successful, he needed an ecosystem of things. And by patenting all of these things, in the case of Tesla, he can prevent someone else from preventing people from putting charging stations in. So strategically, he's inventing and patenting things that are not core to what he's doing for his business, but enable parts of his business. Does that make sense? Same for a nonprofit. Why should a nonprofit ever patent anything? Because you don't want to be blocked in your mission by somebody who holds you up. You can control it. So it's another way of thinking it. It used to be that patent strategy consists of patent what you invent and make sure you don't infringe. That's perfectly good. But strategically, you might do other things with the property. You might enable people. There are a whole bunch. If you start thinking that way, things open up. You might patent things that you don't even care about because your competitor cares about it. You're competing in product A with a competitor who also has product B. I can tell you a whole story of how we helped somebody get out of a jam with that. Okay. Question of which of these IP things you choose is really back to strategy. Do you have a core technology? Is it something people can engineer around? Is the lifetime to get to market of this, the 3D printer, those patents expired before this next generation took over. If you're doing a licensing thing, you probably do want to have something you can license, a piece of property. So you want to think through some of these things. Are there other barriers to entry? FDA approval of a drug. If I have a patent on a drug, it doesn't mean I can actually put it in the marketplace without FDA approval. So other things to think about. Practical advice. Employees typically will sign invention and non-disclosure agreements. These will say anything you invent while you're working for here will be owned by the company. You'll disclose it to the company, and the company can patent those, and you'll cooperate. Very typical, especially if you're technical. Sometimes they have non-compete things in them. There's a whole thing going now with the FTC about non-competes. In California, they're not enforceable except in the connection with the sale of a business. Anyway, so you want agreements with your employees. With consultants or independent contractors, you want to have an agreement that covers work for hire and ownership. Non-disclosure agreements with third parties if you're trying to keep things secret, especially if you haven't yet filed an application. Better thing is to make sure you have a provisional on file if it's something patentable. Avoid infringement, get a freedom to operate opinion. Monitor the landscape. You can use IP vision, see the forest to continually monitor what's happening. Preserve your patent rights using provisional applications. Make sure you file before you disclose to others. And then avoid being picket fenced. Just a quick thing in dealing with lawyers. You're buying expertise by the hour, so I have a whole article here in the materials. So if you came into the patent lawyer and dumped your lab notebook on the desk and said, write me a patent, that's going to take a long time, right? But if you sit down and write the components of it to describe why did you invent it, why it's better than other things, write that out on your time and let the lawyer spend time on the important claims. You'll get a better patent, all other things considered. Okay. Quick thing on university licensing. A lot of federal dollars go into research universities like MIT. It used to be that the federal government owned all the IP that came out of that research. The Bayh-Dole Act back in 1980 said, well, wait a second, having people in Washington try to manage patents or inventions that are done at MIT and Stanford and Chicago, we should push that out to the universities and let them have ownership of whatever comes out of the federal thing, but they have to make sure that they have a process for getting that stuff into the market. That gave rise to the university licensing. At MIT, it's the Technology Licensing Office, and MIT claims ownership if you make significant use of MIT facilities. An example of that would be the nuclear reactor. Using Athena is not a significant use. If it was administered funds like research funds that were administered by MIT, even federally funds, MIT would own those. And textbooks are an exception, and MIT never assigns ownership to the people that sponsor research. They have to actually license it. And then they can waive rights to you under these kind of conditions. So if you're in a lab and you come up with an idea and you think there's an issue, you can go to the Technology Licensing Office and say, I've come up with this. Do you guys want to do anything with it? And they could waive it. You don't want to try to sneak an invention out of MIT if MIT has claims, because it will be tripped up when due diligence is done, either by an investor or acquisition. There is a procedure. MIT's got a lot of ideas that float around that aren't sponsored specifically, like the Despondé Center, gives money to foster ideas that are just ideas out there. So if you have an idea, you can go to the technology office, licensing office, and if they accept it, then they can go ahead and prosecute it for you and use the royalty sharing. For a startup, MIT's licensing office used to just deal with big companies, and then they said, well, look, a lot of the innovation is in startups and small companies, so how do we deal with them? So they started to be able to license to them. And taking equity, I'll show you that in a slide, but if you're a startup and you're trying to figure out, I'm going to go out and try to raise money, and I don't have a license yet, so you can actually get an option to license. You go in and you make your case with your venture plan, and you say, here's what I'm planning to do. You'll get an option to get a license, and with that, you can go to investors and say, here's my plan, here's my team, I've got an option to license it, we need your money, we take the license, the team comes together, and we're off and running. That's the theory there. Here are components. Typical. This is a few years old, but it's not issue fees, or when you sign the license, how much it might cost. Maintenance fees. You have to pay a certain percentage of running royalties for that. In any case, you can't take the invention from MIT and leave it on the shelf. They want to make sure you get it out in the market. Royalty is a percentage of sales. It's 3 to 5%. If they don't take equity, it might be lower if they do. Patent costs, you have to pay for the patent prosecution costs in any event as they occur over time. And you don't have to sponsor any research. Here are some examples of typically single-digit equity that MIT would take. And it would not be diluted through the first round of financing that got you to what your plan said. Here, again, this is about 10 years old. So here are some typical royalty percentages depending on the nature of what you're licensing. These are all on the deck, so you can check them there. Okay, so we've keep an eye on time. All right, we're doing all right. Okay, what about the legal entity? We have the idea. We've figured out we have rights to it. We've protected it. Do we have to do anything else? Well, if you don't do anything, and there's more than 2 or more of you, you may have a general partnership. And a general partnership is 2 or more persons entering into business for profit. And you don't have to have an agreement. And the problem with that is you have joint and several liability. And what does that mean? It means if there's a lawsuit, they can sue either one of you or both of you. And so this is not a good thing for investors. I've got the money, you've got the idea, we form a general partnership, there's a problem, they're going to come after all of my money, right? So investors don't like that. So when you go through all of it, there are a number of things we could talk about, limited liability companies, but for a lot of the tech startups that we'll see, it's typically a Delaware corporation. In Delaware, because it has the most advanced corporate law. There have been plenty of cases tried there, so people understand more clearly what's supposed to happen in certain events. And you should incorporate sooner rather than later if you're serious about this. It's to avoid personal liability, partner liability. These would come from we're always liable for our own acts. So if you come up with a defective product, somebody came to me and said, well, if I incorporate, I'll be protected. And the point is, if you're the inventor of something that's defective, you're still going to get potentially sued. So you're always liable for your own acts. What people care about is, am I as a partner or an investor liable for what you did? And if so, to what extent? So that's what that's about. You want to minimize personal tax, and this is section 83. I'll come to that in a moment, very important. When you do incorporate, make sure you follow all the formalities, keep minutes, make sure you've got a bank account in the corporate name instead of your personal name. You might want to make a subchapter S election. So when you incorporate, that's state law, state by state. Federal taxation of corporations, there's either, if you do nothing, it's subchapter C. We'll talk about what that is. Or if you make an election or eligible, subchapter S. And here's what happens. S, you have to have, it's pass-through. It means there's no tax at the corporate level. In a C corporation, you make $100 of profit. The corporation pays taxes on that. When that money is distributed out to you as a shareholder, you pay taxes. So 2 layers of tax. In an S corporation, no tax at the corporate level. The attributes flow out to the shareholders in accordance with some formulas. So here's an example of the differences. So you'd say, well, you know, for most startups, we're not making profit anyway. We take the money in, we're developing the product. So what's the big deal? Well, the big deal is when you're acquired. Often the acquisition will be of the assets of the company, because that way the acquirer knows exactly what he's getting, the assets, and assumes certain liabilities. And if that is sold at the corporate level, there'll be a corporate level tax, and then the money is distributed out to the shareholders. In a sub C, in a subchapter C corporation, the effective tax rate is about 50%. And under current law, it'd be about 37% as a subchapter S. So this could be 13% could be big if the number is big. So it's worth doing it. Got some examples, I could talk about that. Now, something that trips people up all the time is Section 83. 83 says, if you receive property in connection with providing services, and property in this case is stock in a company, is property, you have ordinary income when you receive that stock, equal to the fair market value of the property. What's the value of the stock minus what you paid for it? Okay? Example, you're the entrepreneur with the idea. I'm Mr. Moneybags, right? Mr. Wonderful on Shark Tank. I like your idea. I'll give you $1 million for 50% of the company. Let's set it up. You say, great. Well, what does that mean? Well, what's the fair market value of your 50%? The only assets in the company are going to be the $1 million plus some ideas. So maybe the value of your stock is $500,000, and what did you pay for it in my example? You have ordinary income of $500,000, and just for math, make the math easier, let's say a 40% tax rate, $200,000 in cash you have to pay the federal government. Oops. You could argue that if I bought half the company for $1 million, what's the other half of the company worth? $1 million. So it could even be bigger. Ouch. This is very unusual. Normally, you know, you go to work for a company, you get a salary, you get your check, and you grumble, God, taxes, Social Security, you know, but at least you have cash, right? Here, you get a piece of paper that you can't do anything with, and you pay taxes. Not good. So what happens? Oh, and it gets worse. So, you know, typically if I'm the investor, right, I'm going to want you to vest over time, because you promised, I have this venture plan, I'm going to execute it. I'm going to put the $1 million in. I did everything I said I'm going to do, but you haven't done anything yet except get my money. So I want that stock to vest over time. You know, maybe 25% after a year, and then quarterly thereafter. If you leave, I want some of that stock back so I can try to go out and get somebody else to come in. Well, the measurement of ordinary income, if it's vesting, is when the vesting kicks in. So let's take a simple case of it's a 4-year vesting. You vest after 4 years. Maybe the stock was worth $0.01 a share when we gave it to you, and it's worth $100 a share when it vests 4 years from now. Ooh, that's a problem. So what you can do is you file an 83B election, which says, I want to take the tax hit today. You have to do that within 30 days of the date you get the stock. You file it with the company, and you file it with the IRS. So how to avoid this problem? Well, remember, in my scenario, you were getting the stock at the same time I, the investor, got the stock. So if you can separate those two, let's say you come out of the class tonight and you say, I get it, I'm going to incorporate, I'm going to issue stock today, and then I'm going to work on my plan, and 6 months from now, I come to Joe, and Joe's going to put money in. You already have your stock, so there's no 83 problem. On the other hand, if I give you a term sheet today, and you incorporate today, and we close a week from today, what happened in that very short period of time? Really nothing. So if you separate those two in time, you avoid the problem. Now, the reality is many people don't do that. Well, we're too busy, we don't know sure who should get what. We had that whole discussion of founders about 50-50 owners or whatever. Especially in technology companies, here's what I've seen, especially is you've got relative importance is the vertical axis and time is the horizontal. And you have two people. You've got the technical person and the business person. So at the beginning, the technical person's relative value is high because if the thing doesn't work, we don't have anything. And the business person has nothing to really work with yet. The question is, so the natural reaction is the technical person will say, oh, I want 95% of the company. Because it's my idea, I'm going to be in the labs. You know, the business person's working at a consulting firm, working on this on the weekend. They have other options. And it's the technical person, it's my baby. But over time, what happens? What's the relative importance? And I think over time, it looks like this. Whether they cross or not is a different thing. The relative importance of technology decreases, and the relative importance of business increases. So recognizing, as you talk about who's going to own what, that if we get these two, both have to come together for something, and those discussions get put off until there's maybe a term sheet. Now we have to figure something out, and then we're into 83. So it's a problem that I've seen over and over again. Okay, as I said, I'd rush through this a little bit. People, founders. Last night, in a couple days, we talked about getting a founders agreement. Mindy was here last night leading some exercise on what that agreement might look like, some of the factors. You can see the founders memo on the website. Important things when you start a company, especially small companies, everybody owes each other a fiduciary duty to be working for the company and for each other. So you really need to make sure you understand what we're doing. You might want to put restrictions on the stock when you issue it. You know, can that be handed off to someone else? What about, I've seen, in order to have a subchapter S, you have to have fewer than 100 shareholders. They all have to be human beings. By and large, there's some trust exceptions. And they have to be, there can be no non-resident aliens. So if we have a subchapter S and I sell my stock to a French citizen living in Paris, I've destroyed the subchapter S status. And I've actually seen a situation where, because of a fight among shareholders, someone tried to transfer their shares to break the S election. So once I saw that, we always put restrictions on transfers that would break the S election. Now, when it comes to founder equity split, there is a market out there for talent. And if people expect equity, that's one thing. On the other hand, Keenan Systems was a company founded by an MIT professor. He owned 100%, sold it for $1 billion to AT&T, I think it was. His employees were very well compensated, and they got bonuses when it was sold. But his view was, you know, I'm in control, I own all the stock, versus everybody gets some. The first job I took was in a spin-off of Pew Roberts in Cambridge. We had the top floor of a triple-decker. I was employee number 3. First day, I go downstairs to go to the bathroom in the mid-morning, and there's a little half bath under the stairs, and I open it up, and the entire bathroom was papered in real stock certificates. And I began to think, I wonder if I'm working for wallpaper. Right, so the question is, do people really understand what stock is and how it works. So you should think about that as part of your culture. Now, what part of the company, somebody once said to me, in an ideal world where everyone would be happy, if my startup eventually went public and the investors owned a third, and the founders own a third, and the employees own a third, everyone should be happy, right? That would be a home run. Often doesn't come out that way. When venture money comes in, the first serious round, they look at the plan, they look at the projections, and they say, okay, you want this much money, and you're going to execute it, you're going to need some equity to execute on that plan. And so typically they'll say there's a pool for employees and others. And it could be anything, but 12 to 18% is not uncommon. If you've got a more fleshed out senior management team, it's closer to 12% because already presumably they have some stock. If your plan is we're going to have to hire in a CEO, it's probably towards the other part, and it's typically enough to serve for 2 to 3 years according to your plan. All sorts of people will take part of that. There's a whole description, a YouTube I made, which I think I'll have to check whether the PDF I put up on the website has that as a live link, but there's like a half-hour thing that goes into more detail on this sort of stuff. This is from Charlie Tillett's slides the other night. What are typical ownership after 2 rounds of financing? Or this might be not atypical. And again, this is in the slides. And Charlie put up on the website and showed you his dilution spreadsheet where you can actually model this out. So when you're talking to people about giving equity to them, what I like to do is say, well, the people we've got investors who think the company's going to be worth this much. We don't know whether it is. We're probably going to need this much further dilution. So what you're going to get will equal this much if those conditions hold. And if it's going to be valuable and we get this much money, here's what your stock might be worth. There's no guarantee, but to try to explain to them, why they should take less than full salaries and work ridiculous hours other than for the glory of, what you're doing. Different forms of equity. I'm going to rush through this looking at the time. Restricted stock and then stock options. Restricted stock is stock that you give to somebody outright, their shareholder. If they're an employee, you have the 83 problem. So your early employees will probably want to take the stock because the value is going to be low, and the taxes, if they file the 83B, is probably going to be small. If you've raised a bunch of money over time, the value of that stock is going to be higher, and it's going to cost them out of pocket to get the stock outright. And so typically, at some point, you'd switch to options. And there are 2 types of options. One's called incentive stock options, or ISOs. These are given, they're under the tax code only for employees. They have to be, the exercise price, that is the price at which they can exercise the option, has to be the fair market value on the date of grant. So let's say the fair market value today is $1 a share. They have a 10-year life. 8 years from now, the company is getting acquired. They exercise their option. They pay $1 for every option share they get, and then they can sell it for the $100 a share or whatever the price is then. They typically vests over time. There's no tax on grant, and there's a possible alternative minimum tax on exercise. I'll leave it at that. It's only if you have a lot of stock options. The typical rule is, though, if you're going to get capital gains, if you hold the stock that you get on exercise of the option for at least 2 years from the date the option was granted and 1 year from the date of exercise, then that will be capital gains, which is a lower tax rate. If you don't hold it then it's ordinary income. But at least you time when you get that income. You'd only exercise an option, when there's a cash out event, unless you just want to hold the paper. Yes?
Fair market value would be calculated
There's a thing called 409A that the IRS has come up with where you actually go out and get an appraisal. The last time I did one of these 2 or 3 years ago, it was about $3,000. So it's an independent appraisal. It used to be the board would make an estimate. So 409A valuation reports are what people do today. It gets especially difficult if you're granting options like the year before you go public, because if the price is going to be $15 when you go public and you're granting options at $2, the SEC and the IRS get a little concerned about that. Okay, non-qualified stock options or other options. By the way, an option, I should have said, the option is a right to buy a share of stock at a given price for a given duration. An option. ISOs, incentive stock options, have to meet certain requirements. Non-qualified, and they can only be granted to employees. Non-qualified can be granted to anybody. They don't have to be granted at fair market value, but there might be some accounting issues involved. Typically they are. There's no tax on the grant or vesting, but when you exercise a non-qualified option, you're taxed at ordinary income for the difference between the fair market value of the stock you get when you exercise and what you paid for it when you exercise. That spread is ordinary income. The company, on the other hand, gets a deduction for that. Sometimes you can, so it's a non-tax deduction. Yeah, so in other words, normally when you get a tax deduction, you have to spend money and you get a deduction for the expense. When a non-qualified is exercised, the company gets a deduction equal to the amount of income that you took into account. And sometimes if you're a senior kind of person, you negotiate, an additional grant of money to offset some of it. But conditions, vesting conditions, as I mentioned, typical 4-year vesting is typical. 1-year cliff, 25% after the first year, if you're still with the company. And then either monthly or quarterly vesting for the next 3 years. So if you've been sitting around for 4 years, you're now fully vested, meaning if you exercise, you get all the shares you said, or if you have a restricted stock, you get all those shares. What you really want to do, you're giving the stock out because you want to get something done. And so people would say, well, I really don't care how long we work on it. If we don't get the product in the market, why should you have any equity? And that's called performance vesting. The problem with that is, companies pivot, products change. And so to write a performance vesting that's meaningful and workable is very hard. So time vesting becomes sort of the standard. It figures, hey, we're all going to be in the rowboat together. We're all going to row. As long as we keep rowing as a team, we'll earn it. If we decide we're not going to do apples, we're going to do oranges, we're still rowing together to do that. So that's the typical thing. Other question is what happens if there's an acquisition or going public? Does the vesting get accelerated? Whole big discussion we can have on that. I think it's partly in the video that I said. Okay. Yes. Quick. Who was? Who? Yeah.
My question is, you have an employee working for your startup. You got this type of option for 1 year. After, and they left the company.
Right here. You have to exercise within 90 days after you leave, if you're an employee, unless it's by death or disability. Does that answer the question?
No.
Okay, all right.
I have a company that the employee left after 1.5 years.
Yeah.
When can they exercise it, and until when, is there the...
Okay, so what happens is that the question is, I have an employee, they leave after 1.5 years. And if it's 4-year vesting, the first year they'd have 25% right to exercise 25% of the options. And then let's say it's quarterly, what is that? Whatever 2/4 of 75% is. when they leave it a year and a half.
Year and 2 months. They got the 0.5%, right?
Yeah, now they leave, yeah. So they have to exercise within 90 days after leaving. If they don't, you can't exercise. That's the ISO rules. In other words, they can't sit out there. If they actually own the stock, if they got restricted stock, they still have the stock, and you take it back. The other thing, if you give out restricted stock, they're actually shareholders. I mean, they actually entitled to vote and things. Option holders don't have a right to vote or get any information about the company in most cases. I'm looking at the time. Do we have our, they're here, they're okay. And the founder's memo covers this. All right, I'm not going to get to this, it's typical. The basic thing is, if you're selling or offering securities, there's the securities laws out there that you really have to worry about. And when it comes time to raising money, you really should talk to somebody who legally knows what you're doing on that. That's why when I said don't put in your plan, we're offering, we want $1 million for 20% of the company. That's an offer, and you can run afoul of the securities laws just for saying that. Private placements are a way to do that. You can read about that. I only have about 3 or 4 minutes here. There we go. And then I have a whole section here on a capital structure. Suffice it to say, for when your investors come in, if they're coming in other than for, let's see. Let's talk about this because you're going to run into this sooner than the other. So early on, because of cost of trying to figure out how to do all the paperwork for this, there's become a trend to do either convertible note financing, which says I'm going to give you a certain amount of money for a note. It's debt of the company. It will convert into equity in the company at the same price as when you raise a bigger round. And then there may be a valuation cap or a discount. You can read about that in this, but that's a convertible note. It's debt, which means, they can have claims on the company. There may also be imputed interest. So it's something that they do. Traditionally, it was just to bridge between rounds. The existing investors would extend money between rounds until the next guys came in. It's now a very typical thing for early stage companies. Because it's debt, there's an example of it. A Y Combinator came up with something called a SAFE. I always forget, simple agreement for future equity. This is simply an agreement that says, I give you X dollars, and you agree that those X dollars will convert into the equity you give out when a bigger round comes in at a conversion price, maybe with a discount because you've been using my money to increase the value of the company. And that's not debt, so it doesn't run into all those things. So I think you heard one of the founder panels or company things talking about a convertible note or a SAFE. That's what this is about. And then we would, the typical thing when you get into serious round is, the money's coming in and the investor says, well, when I put my money in, I've done everything. You still have stuff to do. I should get first crack at stuff that comes out. And the typical instrument when you get to Series A is called a convertible preferred stock. That means they get paid out first, and then they can, and either that or they can convert into the common stock at a conversion ratio. There are a whole bunch of slides in here about the conditions around a preferred stock, but we're running out of time for that. You can look through the deck, and there's also some videos that go into more detail about that. But I've tried to cram into 90 minutes enough red flags that you should think about, hopefully without mind-numbing you. You can go back and read this. And I'm sure there are a lot of questions. Happy to take them during our 10 or 15-minute break. But with that, I'll say that's legal issues, and I'll go right to the end because I think this is important. thank you, and invoice to follow, since this is all free advice you got tonight. So thank you. We'll see you back in about 10 minutes.